Well, our next guest has been killing it, no pun intended, in the Tyler Robinson trial. He is the young man accused of murdering Charlie Kirk alone out of the love of his trans lover, the government says. Andrea Burkhart is a licensed attorney and breaks down the noise and nonsense. And she says that this case is full of oddities. She's an experienced criminal defense lawyer, so she would know. If you're not watching her channel, it's at A. Burkhart Law on YouTube. And then I want to invite you to subscribe because she's great. So she is going to help us understand what about this case, what about this prosecution is making our spidey sense tingle. Thank you so much for joining me for the first time.
Thanks so much for having me.
Absolutely my pleasure. So can we start with the facts? Because I think I've seen some people saying online, he confessed. This is the government case. He has not confessed. And what proof are they putting up? Because when you read the indictment, it kind of reads like gay teen lit. I don't know what we're going with here.
Yeah. So what we have so far in terms of the public information about the facts of the case derives from two documents that have been filed in the prosecution. There's the indictment that you referred to, and there's also a separate probable cause affidavit that both of those set out kind of timelines of the investigation and what investigators discovered, but contain a few different details depending on which one that you're looking at. And so as far as a confession, this narrative, I suppose, is deriving from portions of the probable cause affidavit that indicate that individuals close to Mr. Robinson, family members, friends, reported that he made statements that implied to them that he had committed the crime. And so these statements are not set forth. We don't know specifically what the allegation is. It's kind of a hearsay statement at this point because it's something that's being reported in a document that somebody else heard in some other type of context. So we don't have a whole lot of information yet about exactly what the details of this supposed confession are. Then we have the extracts. They appear to be extracts from what the law enforcement is telling us are communications between Tyler Robinson and Lance Twiggs. And we can tell that they're extracts, or it appears that they're extracts, because there seem to be ellipses indicating that parts of the text messages have been omitted. So it doesn't appear to be a full picture of a conversation, but it does purport to set out verbatim copies of a conversation that Mr. Twiggs, according to the statement, showed law enforcement on his phone. So at this point, it's not something that, as far as we know, law enforcement had personally obtained. They had not extracted his telephone. They had not obtained these messages from any kind of exchange server. So there's still a lot of questions in the air as far as not just authenticity, how exactly are these messages going to be authenticated to be sure that they are what we're being told that they are, but also what's the greater context here? What has apparently been omitted from those messages, and are we going to have an opportunity to find out?
Oh, that's strange. I didn't realize that they hadn't even taken a file from like an iMessage log. They just say they saw it, like the note they say existed. Gosh, that's weird. And I don't read a lot of murder indictments, so the way that it's written about how the parents recognized him is almost stupid. It's so poorly written. The mom thought the images on TV looked like her son, and the dad agreed, and then the dad also thought that the shooter on TV looked like his son, and the mom agreed, and then later they both thought that they looked like... But is this kind of moronic writing normal for something, or does that also make your spidey sense tingle?
Well, it's not unheard of. And part of the thing to bear in mind with this as well is that this is a very preliminary stage of the investigation that's being reflected in this document. And so in this particular case, like many cases where there is a high profile incident like this and there's not an immediate arrest. So we have some public information that is being released as the manhunt is ongoing, as the search and the effort to solve the crime is ongoing. But the suspect is not identified until very late in the process. And so often what that means is that these preliminary documents that are filed in the case give you just the bare bones of what led law enforcement to this suspicion of this individual in the first instance. But much of the investigation is only going to take place after that arrest. And so a lot of that is not going to become publicly available unless and until we move to the next stage of the process, which is ordinarily a preliminary hearing in the state of Utah. And that's where the state has to present its evidence to demonstrate that there is probable cause to charge Tyler Robinson with these specific crimes that he's been charged with. So a lot of times in this situation, the type of information that you would expect to get after the arrest and not necessarily be contained in these preliminary documents would be things like cell phone extractions, subpoenas to cloud servers, to Discord servers, other potential sources of online communications, to cell carriers. A lot of that type of information is often only obtained after the suspect has been identified. And just because of the nature of this crime, the arrest is the first priority. So there is a lot of open holes, I think, and questions that I certainly have about the information that's been provided so far. But I recognize that this is still a very preliminary point of the process. And so the real test of the state's case, I think, is going to come when we get to this preliminary hearing stage and see it's put up or shut up time. What are you able to bring to the table to prove that you have the goods on this crime?
Right. And is it unusual that reporters are saying that Robinson did not choose his defense? We've had reporters saying they had a ton of lawyers who wanted to represent him because they didn't believe the official story, and they were told the state would be choosing his defense. That seems strange that they can choose their opponent. Is that normal?
Well, so the way that it works is because he's been found to be indigent by the state of Utah, meaning he lacks the resources to hire his own attorney. So he's entitled to a public defender. And given that this is a capital case, Utah is one of many states that has certain minimum qualifications for public defenders who are going to represent folks charged with capital crimes. So that's what ultimately led to the referral of his case to a commission that is essentially a defense commission that was entrusted with the responsibility of looking for a qualified Utah attorney to be able to serve as lead counsel in his case. And that is how Ms. Nestor, his primary attorney, was ultimately identified and appointed. Subsequently, there have been a couple other attorneys as well, two from the state of California and one other from the state of Utah, that have also appeared in Mr. Robinson's case. So it does appear that he's managed to acquire a pretty high level and qualified defense team, notwithstanding the fact that perhaps they're not the ones that he would have chosen. They're not the ones, he's not paying for them. It is going to be, he's going to be defended at taxpayer expense.
Interesting. And it was you who flagged for me, because I subscribe to your Substack, that the judge is also really new. He was only appointed in May. So that's also something worth considering. I want to tell you about the wellness company and a new product they're making. You may have heard of it. It's called ivermectin. Now, what if the medicine that helped save millions during the pandemic was made mostly in China? Well, that is actually true. About 58% of the world's ivermectin supply does come from China, 75% from Asia overall, but not the wellness companies. They have introduced America-made ivermectin. It's safe, trusted, and produced right here in the United States. Now, you know, ivermectin has been prescribed for more than 30 years and has even earned the Nobel Prize in Medicine for its proven ability to eliminate parasites and support overall health. New research also points to beneficial skin, immune system, and cancer support. Most pharmacies charge $5 a tablet, but not the wellness company. They're offering a higher 18 milligram dose for just $3.33 each tablet. Plus, you'll get a 6-month supply designed for 4 21-day cleanse cycles, all at this unbeatable price. So support American medicine, not China's supply chain. Get your U.S.-made ivermectin today. Go to twc.health/redacted. When you use the code redacted, you'll save $30 plus get free shipping as well. So check them out. Have your own supply in your house. Do not trust pharmaceuticals to supply you with this medicine. Again, go to twc.health/redacted. Now, you point out the gag order is exceptional for many reasons, one of which is that the media is not questioning this case. So who is it gagging, do you think?
Well, you know, this gag order is quite peculiar. It's kind of becoming commonplace in these high-profile trials for gag orders like this to be handed down. The courts are trying to prevent the parties from litigating the case in the court of public opinion. They want people to hold their cards close until it's trial time so that they don't risk potential jurors learning too much about the case and perhaps forming opinions about it before we're at the point of trial. So these gag orders are becoming commonplace, but the problem with them is that there are some First Amendment considerations that are pretty significant at stake anytime an order like this is issued. There's kind of some different standards that apply depending on who you are talking about gagging. Based on the U.S. Supreme Court authority, it seems to be pretty well understood that you can't tell the press not to report information. If they hear it in open court or if they generate it through their own independent leads, the press has the right to report it. On the other end of the spectrum, the attorneys in particular are officers of the court. We have ethical responsibilities and duties that we have to follow. And because of that, our speech can be limited to much greater extent than the speech of the press. But then in the middle, you have all of the other participants, the law enforcement, the witnesses, the family, people who may have some type of information about the case, but aren't necessarily within one of these fairly clear categories of can their speech be regulated or not regulated. And so those types of orders generally are disfavored, but they may be allowed under some circumstances. There's just a very strict standard that has to be met for that type of restriction on one of our fundamental freedoms to be justified. So what's peculiar about the order in this particular case is that it's not necessarily that clear who it does apply to. If you read the order strictly, you look at the language and you just go by a very strict interpretation of what it says, it only applies to the lawyers in the case. But it's written in such a way to imply that the lawyers are responsible if law enforcement or witnesses or any other investigators, individuals involved in the case, if they were to make public statements about the case, that somehow those might be attributed to the lawyer could be at fault, perhaps there'd be a sanction to the witness. It's all quite unclear. And the problem with that is that one of the hallmark rules of the First Amendment in this type of context is that if you're going to restrict somebody's speech, you must be absolutely crystal clear about what's allowed and what isn't, because otherwise you have a chilling effect. You run the risk that people are going to self-censor out of fear that they may run afoul of your order without even knowing it. But as you pointed out, it's a bit strange to me that there has been no pushback, no media attention, really hardly at all to this gag order, not just the fact that it exists at all, which you would think would be somewhat offensive to a free press, but certainly the kind of obvious problems with it that so far have gone completely unchallenged.
Yeah, it's strange. We have a commenter in our chat that says, Eagles262 says, weren't there lawyers that were offered to work for free for Robinson? Did he not have the choice to choose, or because you said they needed this certification to reach this certain level of ability to practice law?
Yeah, so this is a good question. When you are requesting or qualifying for a court-appointed attorney, you don't get to choose who that attorney ultimately is.
Oh.
And so if he had, for example, privately retained an attorney, now whether that was he's paying somebody or somebody is agreeing privately to represent him pro bono, that would take it out of the context of that public defender restriction. You do have a right to choose counsel, to have counsel of your choice under the Sixth Amendment. So I don't know how that ultimately worked out behind the scenes, if that was maybe, I don't know, something that was just never finalized, if he chose to go with the death qualified attorneys that were offered to him from the state. But at any point, if he wants to be privately retained by attorneys who are willing to do so, he has the right to make that change.
Okay. All right. Well, that's interesting. So something happened where he decided not to retain these lawyers who had offered their services, and we don't know what that is. Okay. Well, thank you so much for coming on and offering your time to break this down for us. Again, you can subscribe to Andrea Burkhart's Substack, follow her YouTube channel. She's doing a really great job if you want to understand the nuances of this case, and there's many. So nice to see you for the first time. I hope you come back.
Thank you so much. It's been a pleasure.
All right.
She was great.
What do you make of that?
Wow. I'm just sitting here soaking it all in.
Yeah.
Crazy. But,
especially because this case, people run their mouth about things they don't quite understand, and like, oh my gosh, this, we didn't get to ask her about cameras in the courtroom. I meant to, I forgot, so maybe we can ask her another time. But yeah, wait a
minute, I think she's still here. Is Andrea still here? Maybe she's yeah, there she is. All right, let's get that microphone back over there.
I apologize.
Cameras in the courtroom. Can we do that? What's going to happen?
Yes, absolutely.
Sorry, I forgot.
There has been a little bit of a just a surprise kind of springing on us possibility of cameras being removed in the courtroom. And so what happened was there had been a motion that the defense had filed to allow Mr. Robinson to appear in the court in civilian clothing and without visible shackles. And this is grounded in that same idea of wanting to keep the jury pool fair and objective. If you're bombarded with images of Mr. Robinson in, a jail jumpsuit and doing an inmate shuffle, in shackles into the courtroom, you just necessarily kind of associate that with somebody being dangerous and somebody being probably guilty. So that was the context in which the litigation was set. What happened was that apparently the state suggested, as a way to mitigate that harm, well, we'll just take the cameras out of the courtroom, and then there won't be any images of Mr. Robinson to have to worry about, whether he's clothed in a suit or not. And the defense then filed a reply in which they agreed with that. So this only became public a couple of days before the hearing on this motion regarding his civilian clothing, in part because when the state had filed their response, they filed it under seal, meaning it's private. The public never got a chance to see it. So we never learned that they were taking this position until it came up in the defense's reply just a couple days before that hearing. So it went before the judge last Monday. And the judge, to his credit, did not rule on that motion. He did not grant the motion. He recognized that there are public interests in transparency and in court access. Utah in particular has very favorable rules when it comes to allowing court cameras into courtrooms. So what he ultimately ruled was that essentially, if anybody wanted to re-raise the issue down the road, he would require them to file a separate motion to do that. In the meantime, he held that Mr. Robinson is going to be allowed to appear in civilian clothing, but he will remain shackled. And to mitigate that harm, he's ordered that the cameras in the courtroom are not going to be allowed to show his shackles or show him coming into and out of the courtroom. So ultimately, he reached what I think is a pretty fair compromise between the security interests of people in the courtroom and Mr. Robinson's interest in being presented with the presumption of innocence that he still holds at this time.
Okay, got it. That's an excellent explanation. Thank you so much. So it's not worth like, oh, they're trying to keep us out. You know, that's conclusion is not, we don't make that yet. So
it's not yet, but it's you would not be out of line to be concerned that it may come up again. Just because both parties did seem to be in agreement that they wanted that to happen. So there's no voice for the public at this point in time. The court had sort of served as our representative during that hearing. But should it come up in a motion in the future, then it's going to be something that they'll have to consider the interests of the public and frankly, the legitimacy of the process and the institution. You know, transparency tends to help people appreciate and understand what it is that they're watching. And so the more you do things behind closed doors, the more that people are going to, wonder why you're doing that and wonder if this is legitimate. So this is a very important case. It's a very serious case. And my expectation is that the court is going to recognize that as much transparency as can be allowed under the circumstances is going to be beneficial to that.
Very good. Okay, thank you so much. Thank you for coming back. I think I got all my questions, but I might call you again some other time. Thanks again.
Sure thing.